Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
In today's video, we are going to discuss section 78 to 93 of Bharatiya Sakshya Adhiniyam 2023.
Welcome to Ganga Education. Today we're diving into a really crucial section of the new Bharatiya Sakshya Adhiniyam 2023. Let's get started.
So, here's our game plan. We'll start with the basics of Section 78. Then we'll break it down piece by piece. After that, we'll see how it works in real-life court situations, look at its evidentiary value, and finally, wrap up with a quick guide specifically for your exams.
All right, let's jump right in. We're in Chapter 5 of the Act, which is all about presumptions as to documents. This chapter sets the stage for everything we're about to discuss with Section 78. Today's focus is Section 78 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section deals with a very specific idea, the presumption of genuineness for certified copies. This is a topic that comes up a lot in judiciary and APO exams, so you'll definitely want to pay close attention.
Okay, the legal language can sometimes be a bit dense, right? So let's deconstruct this section. We're going to break it down into simple, core components so you can understand exactly what it's saying. So this is the key line directly from the BSA Act. Now, what does that actually mean in simple terms? It means that if a document is presented to the court and it looks like a proper certified copy, the court must assume it's the real deal. At first glance, there's no questioning its authenticity.
But of course, for this rule to apply, a few boxes have to be ticked. First, the document has to be a certificate or a certified copy. Second, it needs to look like it was properly certified by a government officer. Third, it has to be in the correct legal format. And finally, the court also just assumes that the person who signed it was officially in that role when they did.
Now, I want you to focus on this key phrase, shall presume. This isn't just casual language. In law, it's incredibly powerful. Shall presume means this is a mandatory presumption. The court doesn't have a choice in the matter. It must accept the document as genuine, unless someone proves otherwise.
And that brings us to this concept, a rebuttable presumption. You see, while the presumption is mandatory for the court, it's not the final word. The other side in the case can stand up and say, wait a minute, we challenge this. They have the right to present evidence to prove that the document is, in fact, not genuine. So, we've got the theory down. But how does this all play out in a real courtroom? Let's look at some practical scenarios and the legal principles that guide them. Let's imagine a property dispute. A lawyer presents a certified copy of a land deed that they got from the sub-registrar's office. Because of Section 78, the judge will simply accept it at face value. They won't immediately say, okay, now go and get the original deed or bring the sub-registrar here to testify. The copy is presumed to be good enough to start with.
Landmark cases have really shaped our understanding of this. In State of Bihar versus Radhakrishan Singh, the court confirmed that this presumption is strong, but it's not invincible. It can be challenged. And then, in Kalia versus State of MP, the court clarified that if someone does challenge the document, it's their job to prove it's fake. The burden of proof is on them.
You know, there's a legal maxim that perfectly captures this idea. Acta publica probantia ipsa. It's a fancy Latin phrase, but it just means public documents prove themselves. Because they come from an official source, they are considered reliable on their own, without needing extra proof. And here's another one. Omnia presumuntur rite esse acta. This maxim basically says, we assume that public officials have done their jobs correctly and followed the proper procedures. It's the foundation of the trust the court places in a certified document. So what does all this matter? What's the real legal weight of a document admitted under Section 78? Let's talk about its evidentiary value and how it lines up with the old law. The value of this section in court is huge. It presumes the document is genuine and that the officer had the authority to certify it. This is a game changer because it means you don't have to call that government officer to court to testify, which saves an incredible amount of time. It makes the whole judicial process more efficient. But, as we've said, always remember, it can be challenged.
It's also worth pointing out that this isn't a brand new idea. This principle was present in the old Indian Evidence Act of 1872. The new Bharatiya Sakshya Adhiniyam 2023 has carried this forward, which shows just how fundamental and important this rule is for our legal system.
Okay, now for the part you've probably been waiting for. Let's get really practical and talk about how this section might show up in your judiciary and APO exams.
For your prelims, Be ready for a direct question comparing shall presume and may presume. For the mains, you might get a short note on evidentiary value or a problem-based question where you have to apply Section 78 to a given situation. And if you make it to the interview, a classic question would be to explain rebuttable presumption using a practical example.
So for a final quick revision, let's lock in the three most important things. First, the section number, it's Section 78. Second, the core concept, it's a mandatory but rebuttable presumption. And third, remember its importance for your exams is very, very high.
For more legal content, focus specifically on helping you crack the judiciary, APO, and other law exams. Make sure you stay connected with us here at Ganga Education. Thank you for watching.
Hello, everyone, and welcome. Today, we're diving into Section 79 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section is all about the presumption as to the record of evidence. And let me tell you, it's an absolutely crucial topic for your judiciary and APO exams, so paying close attention here is really going to pay off.
All right, so here's our plan for today. We're going to start with the core concept of Section 79. Then, we'll break down all the essential ingredients. After that, we'll see how it actually works in a courtroom with some important case law. We'll also touch upon the principles behind it, why it's so important for your exams, and of course, we'll wrap it all up with a quick revision.
Okay, let's kick things off with the core concept. So, what is Section 79 really about? Well, it sets up a really fundamental rule for when a specific kind of document, an official record of evidence, is brought before the court. So, what does all that legal language actually mean? Well, in simple terms, imagine this. A document is brought into court. It could be a record of what a witness said, or maybe it's a confession from an accused person. Now, if this document looks official and seems to have been recorded properly, following all the legal rules, the court doesn't just look at it with suspicion. Instead, it starts with a very specific assumption, a legal presumption about that document.
So, the big question is, when does this special presumption kick in? It's not automatic for every document. There are certain conditions, or what we call essential ingredients, that absolutely must be met. Let's break those down.
Think of this like a checklist that the court goes through. First, what kind of document is it? It has to be either a record of evidence or a statement or confession from the accused. Second, where did it come from? It must be from a proper judicial proceeding or recorded by an officer who has the authority to do so. Third, does it look authentic? It should have what looks like the signature of a judge or a magistrate. And finally, and this is the most critical part, it must have been taken in accordance with law. Every single procedural step must have been followed. Okay, let's walk through the flow here. It's a simple, logical sequence. First, the document is produced in court. Simple enough. Second, the court looks at it and sees a signature that appears to be from a judge or a magistrate. Now, if those two boxes are ticked, then bam, step 3 kicks in automatically. The court shall presume certain things. And notice that word, shall. This isn't a may presume, it's a mandatory, a compulsory presumption. So what are these 3 big things the court is now forced to assume? Super important to remember these. 1. The document is genuine. The court accepts it as authentic. 2. Any statements made about how the document was created, like where it was recorded, who was present, are taken as true. And 3. The actual evidence or confession itself was recorded properly following all the right steps. The court starts with the belief that everything was done by the book.
Okay, that's the theory. But how does this all look in a real courtroom? Let's get practical and look at an example and some really important case law to see Section 79 in action.
Let's paint a picture. Imagine an accused person is brought before a magistrate to give a confession under Section 164 of the CRPC. The magistrate carefully records everything, signs the document, and it's later presented as evidence during the trial. The moment that signed document hits the table, Section 79 comes alive. The court will immediately presume, okay, this document looks genuine, and I will assume the magistrate followed all the proper procedures when recording it.
Now, if there is one case you absolutely must know for Section 79, it's this one, State of UP versus Singar Singh. This is a landmark judgment where the Supreme Court laid down a crystal clear rule. The procedure prescribed by law isn't just a suggestion, it must be followed strictly, no shortcuts.
This case really gets to the heart of the matter. The main issue was this: what if a confession isn't recorded exactly as the law requires? Can the court still consider it? And the Supreme Court's answer was a firm no. They said that the phrase, taken in accordance with law, is mandatory. If you don't follow the procedure, you don't get the benefit of the presumption under Section 79. It's as simple as that. And a couple of other important cases build on this. In Pyare Lal Bhargava, the court emphasized that judicial records in general are given a lot of weight. They come with a strong presumption that they're correct. Then, in the famous Kir Singh case, the court confirmed that a confession, when it's recorded properly, becomes a very powerful piece of evidence.
So let's take a step back and ask why. Why does the law have this rule? What's the deep legal principle behind it? And what does it mean for the value of this kind of evidence?
Well, it all comes down to a classic legal maxim, acta publica probanse ipsa. It's a fancy Latin way of saying that public and judicial records prove themselves. The idea is that we should be able to trust official documents from our courts. We shouldn't have to waste time proving that a judge's signature is really their signature. Section 79 is built on this foundation of efficiency and trust in the judicial process.
So let's sum up its evidentiary value. The court accepts the document as authentic. It believes the statements about how it was made. You don't need to call the judge to the stand just to prove they signed it. But, and this is a huge but, this is a rebuttable presumption. It's a strong starting point, but it's not the end of the story. It can be challenged.
This brings us to a classic exam question. You might see this in your prelims or mains. Is the presumption under Section 79 conclusive? In other words, is it an absolute, unbreakable rule?
The answer, and you need to remember this, is a clear no. It is a rebuttable presumption. This means the other side, usually the accused, has a chance to fight back. They can bring evidence to show that the confession was forced or that the magistrate made a mistake in the procedure. So remember that key term, rebuttable. It's not set in stone.
All right, let's get down to business. How can you turn this knowledge into marks in your judiciary and APO exams? Let's talk strategy. First things first, a quick note on the old versus the new law. This same concept used to be under Section 80 of the old Indian Evidence Act. Now, in the new Bharatiya Sakshya Adhiniyam, it's Section 79. The number has changed slightly, but the core idea is exactly the same. What does that mean for you? It means all the old landmark cases, like Singhara Singh, are still 100% relevant and important for your answers.
So for your prelims, be ready for a direct question. They love to ask if the presumption is shall presume or may presume. You know the answer is shall. For your mains exam, you could get a short note on the essentials of Section 79, or more likely, a problem-based question. They'll give you a scenario with a confession that has some procedural mistake, and you'll have to apply the law. And whatever you do, for a mains answer, make sure you mention the state of UP versus Singhara Singh case. It's a real marks booster.
All right, before we wrap up, let's do a super quick revision to make sure all these key points are locked in your memory.
If you take away just a few things from our discussion today, let it be these. First, the section is Section 79 of the Bharatiya Sakshya Adhiniyam. Second, the core concept is the mandatory shall presume rule for official records. And third, the absolute key condition is that it must be taken in accordance with law. Get these 3 points down, and you're in a great position for any question on this topic.
And that's a wrap on Section 79. I hope this explainer was helpful. For more deep dives into legal topics that are crucial for your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. Thank you for watching, and all the best with your preparation.
Hello everyone, and welcome to Ganga Education. Today, we're going to tackle a really important section for your upcoming judiciary and APO exams, Section 80 of the Bharatiya Sakshya Adhiniyam 2023. This section deals with presumptions about certain documents, and understanding its nuances is absolutely crucial for both your prelims and mains. So, let's get started.
So we're looking at Section 80 of the Bharatiya Sakshya Adhiniyam 2023. Now this section falls under Chapter 5, which is titled Presumptions as to Documents. You see, this chapter is fundamental in evidence law because it basically guides the court on what things can be accepted as true without needing formal proof.
In this explainer, we're going to follow a very structured approach. First, we'll understand the core rule of Section 80. Then, we'll break down its essential ingredients. After that, we'll look at its practical application through case law, the legal principle behind it, and its evidentiary value. And finally, we'll wrap up with some key exam-focused points.
All right, let's dive right into the first part. Here, we're going to focus on the main text of the law itself. Section 80 sets out a very crucial rule of presumption related to official documents like gazettes and newspapers.
Now, the key phrase here, and you really need to pay attention to this, is the court shall presume the genuineness. In simple terms, what does this mean? It means that if a document claims to be an official gazette or a newspaper, and it's produced from the correct custody, the court has to assume it's genuine. The court has no choice here. That word shall makes it a mandatory presumption, not a discretionary one.
Okay, let's move to the next part. To really get a grip on Section 80, we need to break down its legal language into essential components. This will make it super clear what conditions have to be met for this presumption to kick in.
So look at how this slide simplifies the entire section. There are basically 4 key ingredients. First, the nature of document. It's got to be an official gazette, a newspaper, or some other document that the law requires to be kept. Simple enough, right? Second, substantial compliance. It has to be kept in the way the law says it should be. Third, and this is very important, it has to come from proper custody. And finally, the big effect, shall presume, which means the court must accept its genuineness.
So the crucial point here is understanding proper custody. What does the law mean by this? Well, it's simple logic. A government document should be with a government officer in a government office. That is proper custody. But the law is also practical. Its explanation makes it clear that if you can prove the document's origin is legitimate, meaning its journey can be traced from an official source without any suspicious gaps, then the court can consider that custody to be proper as well. Now that we've covered the theory, let's see how Section 8 actually works inside a courtroom. Because let's face it, theory is one thing, but it's the practical application that you'll face in your exams and in practice.
And this slide illustrates the process brilliantly. It's a 3-step flow. First, a party presents a document, say a newspaper, as evidence. Second, they have to satisfy the court that it came from proper custody, like it was taken from the newspaper's official archives. Once these 2 steps are complete, the third step is automatic. The court applies the presumption and accepts the document as genuine.
Let's take a common exam-oriented example. Imagine the prosecution needs to prove that a new law was officially notified by the government. They present a copy of the official gazette. Now, because this is an official gazette produced from a government source, under Section 80, the court will simply assume it's the authentic gazette. The prosecutor doesn't need to call the manager of the government printing press to testify. The document proves itself.
This principle isn't just in the statute books. The judiciary has strongly upheld it. In the landmark case of Ram Ratan versus the state of Uttar Pradesh, the Supreme Court was dealing with the admissibility of entries in an official gazette. The court stated clearly that such entries are admissible, and the court is bound to presume their genuineness. This case reinforces the mandatory nature of Section 80.
Now, let's explore the foundation of this rule. You know, every legal provision has a history and a guiding principle. Understanding this gives us a deeper insight into why the law is written this way.
The entire concept of Section 8 is beautifully captured in this Latin maxim, acta publica probantse ipsa. It simply means public documents prove themselves. The law places a very high degree of trust in the authenticity of official records because they are created and maintained through a formal, public process. This maxim is the philosophical heart of Section 80.
For those of you familiar with the old laws, it's important to understand this connection. This isn't a new idea. The principle we're discussing was previously in Section 81 of the Indian Evidence Act, 1872. The new Bharatiya Sakshya Adhiniyam has repositioned it to Section 80, but the core legal concept has been kept exactly the same. So, we know the court presumes the document is genuine. But how strong is this presumption, really? What's its actual weight in court, and are there any limits? This is a very important question, especially from a mains exam perspective.
This slide is crucial. First, genuineness is presumed, and no formal proof is needed. But pay close attention to the third point, the caution about newspapers. This is a very common trap in exams. The court will presume that a document, say a copy of the Times of India, is a genuine copy. But, and this is a big but, it will not presume that the news story printed inside it is true. The law is very cautious here to prevent what we call trial by media from becoming trial by evidence. So the truth of the contents must be proved separately. And finally, remember that this is a rebuttable presumption. The other party can always bring evidence to prove that the document is a fake. Okay, let's bring everything together and focus specifically on what you need to know for your judiciary and APO exams. Here, we'll distill everything down into actionable points for your preparation. Here's my direct advice for you. For the prelims, you can expect a direct question like, under Section 80 of the BSA, the court shall presume the genuineness of which of the following documents?
For the mains exam, be prepared for a problem-based question. They might give you a situation where a news report is presented as evidence and ask you to decide on its admissibility and evidentiary value. For a final quick revision, remember these three main things. 1. The section is Section 80 of the BSA, 2023. 2. Its core concept is the shall presume rule for documents like official gazettes when they come from proper custody. And 3. This presumption is rebuttable, not conclusive. Keep these points in mind, and your preparation will be complete.
So we'll end with a thought-provoking idea. We've established that the law presumes a newspaper is genuine, but not that its contents are true. Why do you think the law makes this critical distinction between the document and its content? Think about the consequences of assuming every news report is true. This very nuance is the heart of evidence law. For more focused legal explainers like this, stay connected with Ganga Education.
Today, we're going to dive in and decode a really important section of the Bharatiya Sakshya Adhiniyam 2023. That's Section 81. Now, this section deals with the genuineness of electronic records, something that is incredibly relevant in our digital age. So in this explainer, we're going to take a really structured approach to make Section 81 super easy to understand. We'll start with the bare act provision itself, then break down its essential ingredients. After that, we'll explore how it's applied in the courtroom and look at some key precedents. And finally, we'll wrap up by focusing on its importance from an exam perspective with some quick revision points. Let's get right into it. All right, let's get started. We'll begin by understanding the foundational provision of Section 81 itself. So today we're discussing Section 81 of the Bharatiya Sakshya Adhiniyam 2023. This section falls under Chapter 5, which, as you can see, deals with presumptions related to documents. And let me tell you, for the judiciary and APO exams, this section is definitely one to watch. Okay, now let's look at the key line from this section itself. In simple terms, what this means is that whenever an electronic or digital record is presented to the court and it claims to be the official gazette, the court will just assume that it's genuine. Now, those two words, shall presume, they're really important here. It means this is a mandatory presumption, unless, of course, solid evidence is brought forward to prove otherwise. So now that we've got the basic meaning of Section 81 down, let's break down its essential ingredients. This will help us understand its application even better. You see, for a court to actually apply this presumption, certain conditions have to be met, and these are what we call the key ingredients of Section 81. All right, let's take a closer look at this table. First up, the nature of record. The record can't be physical, it has to be in an electronic or digital form. Second, the type of document. It needs to be either an official gazette or some other digital record that's legally required to be maintained. Third, legal form. The record must be kept substantially in the format prescribed by law. And fourth, and this one is super important, proper custody. This just means the document has to be produced from the designated place or person who has the legal authority to keep it. So, for example, an e-gazette downloaded from the official government website, that's considered to be from proper custody. So, is there a legal principle that kind of summarizes the very essence, the soul of this section? Absolutely. We can understand this principle through a legal maxim, acta publica probanse ipsa. It has a pretty straightforward meaning. Official records, which now include electronic ones, prove themselves. You don't need separate evidence to prove they are what they say they are. And this maxim brilliantly illustrates the core of Section 81, right? When an e-gazette is produced from proper custody, the court just considers its authenticity to be self-proving. This really reduces the initial burden on the party to prove the document's genuineness. Okay, great. Now let's move on and see how Section 81 actually works in practice, in the courtroom, and what the Supreme Court has had to say about all this. Let's imagine a scenario. Say the government publishes a notification in the e-Gazette to acquire a piece of land. Now, if that acquisition is challenged in court and the notification is presented as evidence, the court, under Section 81, will presume it's genuine, provided it was downloaded from the proper government portal. Now, to really understand the admissibility of electronic evidence, we absolutely have to look at the landmark case of Anwar PV versus PK Bashir. In this landmark judgment, the Supreme Court made it crystal clear that for electronic evidence to be admissible in court, a certificate under Section 65B of the Evidence Act is mandatory. So why is this case so important in the context of our Section 81? Well, it's because it sets up a procedural framework to ensure the authenticity of electronic records. Basically, it supports the very presumption that Section 81 is built on. All right, now let's get to what might be the most crucial part for many of you, exam preparation. Let's look at the key takeaways for Section 81, specifically for the judiciary and APO exams. So, this provision isn't entirely new. It existed before in Section 81 of the Indian Evidence Act of 1872, but under the Bharatiya Sakshya Adhiniyam 2023, it's been modernized. The biggest change, as you can see, is the explicit inclusion of the words electronic or digital record, which makes it a perfect fit for today's digital era. So, what's the evidentiary value here? What's the bottom line? Well, the court presumes the genuineness of e-gazettes, which means you don't initially need to bring in a technical expert to prove it. This also aligns perfectly with digital governance initiatives. But, and this is the most important thing to remember for your exams, this presumption is rebuttable. That means the other party can present evidence to prove that the e-gazette was tampered with or isn't authentic. Okay, a quick tip for your exams. In the judiciary prelims, you might get a direct question on the section number or its core concept. But for the mains, you could see a short note or even a problem-based question on its evidentiary value, its ingredients, or maybe its relationship with the ONVAR PV case. All right, for a quick revision, just remember these key points. The section is 81 of the BSA 2023. The core concept is that the court shall presume the genuineness of e-gazettes. And most importantly, the presumption is rebuttable. For your exams, its importance is definitely high. And before we end this explainer, I've got a question for you to think about. As technology like AI and deepfakes becomes more advanced, how do you think it might challenge this very presumption of genuineness for digital records in the future? It's definitely something worth pondering. For more legal content focused on judiciary, APO, and other law exams, be sure to stay connected with Ganga Education. Thanks so much for watching, and don't forget to subscribe to the channel.
Namaskar and a very warm welcome to Ganga Education. Today we're going to tackle a really important cluster of sections from the Bharatiya Sakshya Adhiniyam 2023. That's sections 82 right through to 87. This chapter is all about the presumptions related to documentary evidence, and let me tell you, from a judiciary and APO exams perspective, this is absolutely crucial.
So the first question that pops into your head should be this. How can a court possibly trust a document without formal, exhaustive proof? I mean, just imagine if for every single document, the official who created it had to be called into court. Think about how much of the court's time and resources would be wasted, right? Well, that's the exact problem that legal presumptions are here to solve.
Now, before we dive into each section one by one, we've got to understand the one phrase that is the absolute foundation of this entire chapter. And that phrase is, shall presume. Without getting this right, it's pretty much impossible to understand what these sections are all about.
Okay, so what does shall presume actually mean? Well, to put it simply, it's a command to the court. It's an instruction. Whenever a document mentioned in these sections is presented, the court has no choice but to assume, to presume, that it's genuine. But, and this is a big but, it's not the final absolute truth. We call it a mandatory but rebuttable presumption. This means the court must presume it's true, but it can be proven false.
This table really breaks it down perfectly. You see, it's a two-sided coin. On one side, the court must accept the document as genuine. That's its duty. But on the other side, the opposing party has the right to challenge it. They can bring evidence to show there was fraud or forgery or some other kind of irregularity. And if they succeed in proving that, the court will throw the presumption out.
All right, so now that the principle of shall presume is crystal clear, let's move on and see how it's applied across the 6 different categories of documents covered in sections 82 to 87.
This table is really the heart of the entire chapter. Let's quickly go through it. Section 82 says government maps and plans shall be presumed genuine and accurate. Section 83 does the same for government-authorized law books. Section 84 is a big one. It says a power of attorney executed before a notary or a magistrate will be presumed to be properly executed. And then we have sections 85, 86, and 87, which are so important for our digital age, giving legal recognition to electronic agreements, secure electronic records, and digital signature certificates.
So, we've covered the theory. But how do these sections actually play out in a real courtroom? Let's walk through a practical example to see it in action.
Let's imagine a property dispute. Party A presents a power of attorney that was executed before a notary public. The moment they do that, the court, under Section 84, will immediately presume that the document was properly executed. Now, what does that do? It completely shifts the burden of proof onto Party B. It's now Party B's job to prove that the document is fake, that there was fraud or coercion or forgery. If they can't prove it, the document is considered perfectly valid. See how powerful that is?
And this very principle was firmly established by the Supreme Court in the landmark case of Jugraj Singh versus Jaswant Singh. The court made it perfectly clear. If a power of attorney is authenticated by a notary, the court is bound to presume its validity. The onus is entirely on the person who objects to it to prove it's invalid.
You know, all of these presumptions are based on a fundamental legal principle, a Latin maxim, omnia presumuntur reit esse acta. It basically means that the law assumes all official acts, like notarization or the creation of government maps, have been performed correctly and according to the rules, unless and until someone proves otherwise.
So, at the end of the day, why are these presumptions so important? How do they make the judicial process easier and more efficient?
Well, their biggest advantage is that they reduce the burden of proof and save the court's precious time. Because of them, we don't need to call the surveyor for every government map or the notary for every power of attorney. Especially today, they are vital for giving legal status to e-contracts and e-governance. And most importantly, because they are rebuttable, they strike a perfect balance between convenience and justice.
It's also important to remember that not all presumptions are created equal. Documents where authenticity is absolutely paramount, like government records or secure electronic records, carry a very strong presumption. On the other hand, for something like a non-secure digital record, the court might still want to see some other supporting or corroborating evidence.
All right, let's get to the part that matters most for your upcoming exams. Let's focus on the key takeaways for all you judiciary and APO aspirants.
Okay, pay close attention here. For your judiciary prelims, you're likely to see direct questions, like what kind of presumption is there in Section 84, shall presume or may presume. For the mains exams, you need to be ready for problem-based questions, where you'll be given a fact scenario and you'll have to apply these sections to write a detailed, analytical answer.
For a quick final revision, just lock these 4 points in your mind. 1. The core concept is shall presume, mandatory but rebuttable. 2. The scope is sections 82 to 87. 3. The key principle is that it shifts the burden of proof to the challenger. And 4. Its importance for your exams is extremely high.
And to finish, here's a question for you to think about. If a digital signature is presumed to be secure under Section 86, what level of proof do you think is needed to successfully challenge it in court? Give that some thought. For more legal content focused on judiciary, APO, and other law exams, stay connected with Ganga Education.
Hello everyone and welcome to Ganga Education. आज हम डिस्कस करेंगे एक बहुत ही इम्पोर्टेंट टॉपिक आपके जुडिशरी और एपीओ एग्जाम्स के लिए सेक्शंस 88 से 91 ऑफ द भारतीय साक्ष्य अधिनियम 2023। ये चैप्टर डॉक्यूमेंट से जुड़ी प्रिजम्पशंस के बारे में है और लेट मी टेल यू ये एविडेंस लॉ का एक ऐसा क्रूशियल एरिया है जिसे समझना आपके लिए एब्सोल्युटली ज़रूरी है।
So here's how we're going to break it down today. First, we'll get a quick intro to Chapter 5. Then we'll dive deep into each section from 88 to 91. After that, we'll see how courts actually apply these rules in real life. We'll also touch upon their evidentiary value and compare them with the old law. And finally, we'll wrap it up with a sharp focus on what you need for your exams. Ready? Let's go.
All right, let's start with Chapter 5. You can think of this chapter as a kind of legal shortcut. So why is it so fundamental? Well, it's because it gives the court the power to assume certain facts about documents without needing formal proof for every little thing. This, as you can imagine, saves a massive amount of time and effort in judicial proceedings.
Now, these 4 sections cover a whole range of documents, from old-school foreign court records to modern-day emails. But here's the golden nugget. The one thing you absolutely have to notice in sections 88, 89, and 90 is the phrase may presume. This is the key. It means the court has a choice. It has discretion. It's not a mandatory rule. Keep that in the back of your mind as we go through each section.
Okay, let's get into the nitty-gritty. Understanding the specific ingredients of each section is absolutely vital for you to be able to answer those tricky, problem-based questions in your exams. We're going to start with Section AA.
So, what's Section 88 all about? Well, it basically deals with how an Indian court should treat a certified copy of a judicial record from another country. The whole point is to make it simpler to admit foreign judgments as evidence. Now, pay close attention here, because this is a 2-step process.
First, of course, the document has to be a certified copy. But, and this is the key detail, that certification must also be verified by a representative of the central government of India in that foreign country. Only when both these conditions are met, the court may presume it's genuine. Remember, it's not a must. The final call is always with the judge. Next up, we have Section 89. Now, this section is about documents of public interest. Think about things like well-known books, maps published by the government, or scientific charts that are presented as evidence in court. So the crucial point here is, if a relevant book or map is presented, the court has the choice. Again, there's that phrase, may presume, to believe that the person named as the author is the real author, and that it was published at the time and place mentioned on it. It's a huge time saver, right? Imagine having to call the author of every single book to court. All right, now we're stepping into the digital age with Section 90. This is super relevant for us today, as it deals with the presumptions related to electronic messages, like emails. Let's see how the law keeps up. And this is where it gets really interesting, and frankly, it's a favorite question for examiners. The court can presume that the email received by one person is the same one that was sent from the originator's computer. But, and this is a big but, the court cannot presume who the sender was. The content? Maybe. The sender? Nope. The identity of the sender has to be proved separately. Okay, let's switch gears a bit. Section 91 is a bit of a game changer. So far, we've talked about documents that are in the court. But what about a document that isn't? This section deals with a document that a party was asked to produce but didn't. And here is the big twist. Notice the language? We've moved from may presume to shall presume. This isn't a choice anymore. It's a command. If you're ordered to produce a document and you refuse, the court must presume that the document was properly attested, stamped, and executed. This basically creates a penalty, an adverse inference, against the party that's trying to hide the evidence. Okay, so we've got the rules down, but how do they actually play out in a real courtroom? Let's look at the legal principles and the judicial thinking that guide their application. The whole philosophy behind these presumptions can be summed up in one powerful Latin maxim, omnia presumptumeral rite esse acta. It simply means that all acts are presumed to have been done rightly and regularly. Basically, the law assumes that official things are done properly, unless, of course, you can prove they weren't. Now, when we talk about modern evidence, there's one case you just have to know, Anwar PV versus PK Bashir. This is a landmark one. The Supreme Court laid down strict guidelines for admitting electronic evidence. It basically said, hey, just because we have presumptions like in Section 90, it doesn't mean you can just skip the basic legal requirements for certifying and proving electronic records. This brings us to a really critical question. What is the actual evidentiary value of these presumptions? How much weight do they really carry in court? And what's the difference between them? Okay, everyone, listen up, because this slide is pure exam gold. The most crucial takeaway is this. Sections 88, 89, and 90 create discretionary presumptions. The court may presume. But Section 91 creates a mandatory presumption. The court shall presume. It has no choice in the matter, unless the other party can prove otherwise. This distinction is everything. Now, for those of you who might be familiar with the old Indian Evidence Act of 1872, don't worry, you don't have to unlearn everything. The core principles from the old sections 86 to 90 have been carried forward. They've just been consolidated and streamlined under the new sections 88 to 91. All right, let's get down to business. This is the part you've all been waiting for. How to absolutely nail this topic in your exams. Let's focus on the key takeaways. For your prelims, you should definitely expect direct hit questions on may presume versus shall presume. It's a classic. For your mains, get ready for a problem-based question. For example, they might ask, A gives notice to B to produce a contract, but B doesn't. What can the court presume? And the answer, of course, lies in Section 91. Okay, time for a super quick recap. If you remember nothing else from today, remember these 3 points. 1. Sections 88, 89, and 90 are discretionary. 2. Section 91 is mandatory. And 3. The whole point of this chapter is to ease the burden of proof and make court proceedings more efficient. Got it? Good. So, to wrap it all up, just think of these sections as a practical toolkit for the courts. They boost efficiency, they give judges flexibility with discretionary powers, and, most importantly, they ensure fairness by penalizing anyone who tries to hide evidence. And with that, we've covered the essentials. But before you go, here's a little food for thought for your mains preparation. How does the court's discretion under may presume strike a balance between the need for speed and efficiency and the ultimate duty to find the absolute truth? Think about that one. For more deep dives like this, make sure you stay connected with us here at Ganga Education. Thank you for watching.
Hello aspirants and a very warm welcome to Ganga Education. Today we're diving into a really fascinating and important section, Section 92 of the brand new Bharatiya Sakshya Adhiniyam 2023.
So, let me ask you a question to get started. How can a document that's, say, 100 years old prove itself in court? I mean, think about it. The people who wrote it, the witnesses, they're long gone, right? Well, this is the exact puzzle that Section 92 helps us solve. So, let's get right into it.
All right, so this section we're talking about, Section 92, it's found in Chapter 5, which is all about presumptions as to documents. Now, you'll want to pay close attention here, because for your judiciary and APO exams, this section is a big deal. It's all about how we handle the proof and admissibility of really old documents.
Okay, so let's look at the actual wording from the law. It says, where any document purporting or proved to be 30 years old is produced from any custody which the court in the particular case considers proper, the court may presume. Now, what does all that legal language actually mean? Well, in simple terms, it's this. If you bring a document to court that's at least 30 years old, and it comes from a place the court thinks is a legitimate or proper place for it to be, the court can assume that the signature, the handwriting, and all the witness signatures on it are genuine.
To really get a grip on this, we need to break it down into its core ingredients. Think of this as the checklist the court uses. And for you, this is absolutely crucial for writing a solid answer in your mains exam, so let's focus here.
So, what are these key ingredients the court is looking for? First up, the age. Is the document 30 years old? Second, where did it come from? Is it from proper custody? Third, and this is a big one, the court has discretion. It says may presume, not shall presume. And if all these boxes are ticked, then, and only then, can the court presume the execution and attestation are all correct. Let's look at that first ingredient, 30 years old. You might be wondering, when does the clock start ticking? Well, it's calculated from the day the document was actually made, the date of execution, all the way up to the date you present it in court. That time frame is super important to remember. Okay, next up is proper custody. So what does that even mean? It's actually pretty logical. It just means the document was found in a place where you would naturally expect it to be. For instance, the title deeds for a property, you'd expect to find them with the owner of that property. That's proper custody. But if those same deeds turned up in some random stranger's house, the court is definitely going to have some questions. Now, let's really zoom in on those two crucial words, may presume. This isn't just casual phrasing. It's a legal term of art defined right there in Section 4 of the Act. It means the court has a choice. It's not a compulsion, it's a discretionary power. The judge will look at everything, all the facts, all the circumstances, and then decide whether to make that presumption or not. So you can think of it as a logical four-step process for the court. Step 1, is the document over 30 years old? Check. Step 2, was it produced from proper custody? Check. Step 3, if those two are good, the court then exercises its discretion. It may presume. And if it does, that leads to Step 4. The court presumes the signature, the handwriting, and the whole execution process were genuine.
Okay, knowing the theory is one thing, but how does this actually play out in a real courtroom? Let's talk about the practical application.
Let's imagine a classic scenario, something you might even see in your exams. A family is in a heated dispute over a will. This isn't just any will. It was written by their great-grandfather 40 years ago. Now, obviously, the great-grandfather isn't around to confirm his signature. So how does the court decide if it's real? This is the exact situation where Section 92 becomes the hero. And this brings us to a landmark Supreme Court case you absolutely have to know, Om Prakash versus Shanti Devi. The big question here was, is this presumption under Section 92 absolute proof? The Supreme Court gave a crystal clear answer, no. The presumption is rebuttable. This is key. It means the other side can come forward with evidence to argue that the document is actually a fake or a forgery. It's a starting point, not the final word.
And to add more weight to your answers, here are a couple of other important cases. In Harihar Prasad Singh, the court reinforced that these old documents get the benefit of a presumption of due execution. And in Siddaldas, the court really hammered home just how essential proper custody is for this whole rule to even apply.
This whole idea is actually rooted in a very old legal maxim. The maxim basically says that all official acts are presumed to have been done correctly and regularly. The Latin for this is omnia presumanta rite esse acta. And really, Section 92 is just a specific application of this fundamental principle.
All right, with all the new laws coming into effect, it is absolutely essential to know how things have changed. Let's compare the old law with the new one.
This is a simple but critical point for your exams. Under the old Indian Evidence Act of 1872, this rule was in Section 90. Now under the new Bharatiya Sakshya Adhiniyam of 2023, it has moved to Section 92. Please remember this change. It's an easy mark to get or to lose.
Okay, let's switch gears and talk specifically about your exams. How do you take all this information and turn it into high scores? Let's focus on that.
So, when you're asked about the evidentiary value of a document under Section 92, here's what you need to say. First, it presumes the authenticity of the signature and handwriting. Second, it presumes the execution was done properly. This is huge because it means you don't have to track down attesting witnesses from decades ago. But, and this is the most important part, you must always mention that this is a rebuttable presumption.
Here's a direct exam tip for you. For your prelims, be ready for a straightforward question about the 30-year rule. Simple. But for your mains, you should expect a problem-based question, very similar to that will dispute example we talked about earlier. They'll want to see if you can apply the law.
All right, let's do a super quick revision to lock this in. If you remember nothing else, remember these three things. 1. The section is now Section 92 of the BSA 2023. 2. The core idea is a discretionary presumption for documents that are over 30 years old and from proper custody. And 3. The nature of this presumption is rebuttable. It can be challenged.
So I'll leave you with a question to think about. We've established that the presumption is rebuttable. So put on your lawyer hat for a moment. What kind of evidence could you actually bring to court to challenge one of these 30-year-old documents? How would you prove it's a fake? Give that some thought.
For more in-depth legal explainers focused on your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Namaste and welcome to Ganga Education. आज हम डिस्कस करेंगे सेक्शन 93 ऑफ द भारतीय साक्ष्य अधिनियम 2023. ये सेक्शन डील करता है इलेक्ट्रॉनिक रिकॉर्ड से जुड़ी प्रिजम्पशंस के बारे में. जुडिशरी और एपीओ एग्जाम्स के लिए ये सेक्शन काफ़ी इंपॉर्टेंट है. सो लेट्स गेट स्टार्टेड.
तो चलिए देखते हैं आज हम क्या-क्या कवर करेंगे. हम शुरू करेंगे सेक्शन 93 के इंट्रोडक्शन से, फिर बेयर एक्ट की लैंग्वेज को डिकोड करेंगे. इसके बाद हम इसके एसेंशियल इंग्रेडिएंट्स को ब्रेक डाउन करेंगे, एक प्रैक्टिकल एग्जाम्पल और केस लॉ देखेंगे, एग्जाम के पॉइंट ऑफ व्यू से इसकी इंपॉर्टेंस समझेंगे और एंड में एक क्विक रिवीजन समरी करेंगे.
All right, let's get right into it. Section 93, is a really big step in modernizing our evidence law. We live in a digital world, right? So this section creates a special rule, a legal presumption for electronic records that are at least 5 years old. And as you can imagine, this is a very, very important concept today.
Now, what does this legal text really mean? Simple language में समझे तो, a presumption is like a legal shortcut. The law lets the court assume a fact is true unless someone proves it's not. So this rule means that if you bring a 5-year-old electronic record to court from a reliable source, the law calls this proper custody, the court can just go ahead and assume the digital signature on it is genuine.
Okay, to really understand how this section works in court, we need to break it down into its core components. What we lawyers love to call its ingredients. Let's look at what they are. So, for a court to even think about using this legal shortcut, there's a checklist of 4 conditions. And let me be clear, all 4 have to be met, no exceptions. First, the evidence has to be an electronic record. Second, it has to be at least 5 years old. Third, and this is a big one, it must come from proper custody. And finally, it needs an electronic signature. Only if all 4 boxes are ticked can the court proceed.
That third condition, proper custody, is absolutely critical, so let's focus on it for a moment. What does it mean? Well, it means the record comes from a place where it naturally belongs. Think about it, a company's secure server, a government database, or your official cloud storage. Why is this so important? Well, because it tells the court that the document has been kept safe, secure, and most importantly, hasn't been tampered with. It's all about building trust.
Now here's a detail you absolutely cannot miss. Look at the language. The law says the court may presume. It doesn't say shall presume. This is a huge difference. This small phrase gives the judge discretion. It means the presumption isn't automatic. Even if all 4 conditions are met, the judge can look at the whole picture and decide if it's fair to apply the shortcut or not. To make this even clearer, let's visualize this whole process. Think of it as a flowchart. This is basically the step-by-step logic a court follows when it's faced with this kind of evidence. So, you can see the flow right here in this table. The court first asks, is it an electronic record that's 5 years old or more? If yes, we proceed to the next step. Was it produced from proper custody? Yes again? Okay, let's move on. Does it have an electronic signature? If that's a yes too, then and only then the court arrives at the final stage where it can use its discretion and say, okay, I may presume the signature is authentic. Okay, so we've covered all the theory. But how does this actually play out in a real courtroom? Let's move from the books to the real world with a practical example and a landmark case that really set the stage for this law.
Let's take a situation. Suppose there's a contract dispute. Party A submits an email from, say, 2020 as evidence. This email has Party B's digital signature, and it's been pulled directly from the company's secure official server. Now, because of Section 93, the court can initially presume that Party B's signature is genuine. This saves a lot of time and money because you don't immediately need a forensic expert to prove it.
Now, the principles for handling digital evidence aren't entirely new. The landmark case of Anwar PV versus PK Bashir, even though it's from before the BSA, is foundational here. In this judgment, the Supreme Court laid down very strict rules for how electronic evidence can be admitted in court, focusing on authenticity and certification. The logic from that very case is what really forms the backbone of sections like 93 today.
You know, the legal philosophy behind this section is captured perfectly by a classic Latin maxim, omnia praesumuntur right esse acta. It simply means all things are presumed to have been done correctly. This principle allows the court to assume that an official or regular act, like digitally signing a document, was done properly, unless someone comes forward with proof that it wasn't.
Okay, let's zoom out a bit now. It's really important to see how this new law evolved from the old one. And more importantly, let's talk about why this is a high-yield, must-know topic for your exams. So under the old Indian Evidence Act, Section 90 had a similar rule, but it was for physical paper documents that were 30 years old. Now, Section 93 takes that same logic and applies it to electronic records. But look at the time frame. It's been drastically reduced to just 5 years. This big shift from 30 years to 5 years is the law's way of saying, hey, we know technology moves fast, and digital records become reliable much quicker. So what's the actual value of this in court? First, and this is a key term you must remember, the presumption is rebuttable. This means it's not final proof. The other side can always bring evidence to challenge it. Second, its main job is to reduce the initial burden of proof. Third, I'll say it again, proper custody is the gatekeeper. Without it, this section is useless. And finally, just think of it as the modern, digital version of the old 30-year rule.
All right, here's your exam tip. For prelims, you're going to see direct MCQs in the time period. Remember, it's 5 years. And the nature of the presumption, which is may presume. For your mains exam, you're far more likely to get a problem-based question, something very similar to that email example we just talked about.
Okay, let's wrap this up with a super quick revision of everything we've discussed. This will help consolidate the most important points so they really stick in your mind for the exam.
For a lightning-fast revision, just lock in these 3 things. First, we are talking about Section 93 of the Bharatiya Sakshya Adhiniyam 2023. Second, its core idea is a discretionary presumption for signatures on 5-year-old electronic records. And third, the single most important condition, the one you can't forget, is proper custody. And I'll leave you with a final thought to ponder. In a world where technology changes in the blink of an eye, do you think this 5-year rule is the right way to balance that speed with our long-standing quest for justice? It's something to think about. For more judiciary, APO, and law exam-focused legal content, stay connected with Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share, and subscribe to Ganga Education. Keep learning, keep growing, and stay connected for more law lectures.